I can now.
Yes.
My Lord.
Fine. Well, let's resume in that case.
Yes, Lord, I understand that there's been some problem with an excessive volume emanating from my end this morning. I think
the first few minutes, but we were able to adjust the equipment here, and there's not a problem now.
Okay, right. My Lord. Well, my Lord, this morning, when we rose for the recess, I was just taking your Lordship to the UK's own transposition of this, and if I could ask your Lordship's turn to pages 1117 in their bundle.
Yeah. 1117. Yes.
Yes. This is the your Communications Act 2003 in the UK, which it is true to say is drafted in a different and much more modern style than ours. Ours is more script style.
Yes. I don't know. Are Council able to hear Sir Peter at the moment?
I'm afraid I'm having trouble.
Perhaps
yes, we're having the volume.
I am being uncharacteristically quieter.
Yes, I'm afraid so, Sir Peter. We are taking steps at this end to increase the volume, but in the meantime, if you could perhaps try to keep your voice up.
I'll resume my normal style then, my Lord. At that page, at page 40, at section 45, is that any better, my Lord?
It's fine for me. Council can hear you now. Yes, that's fine. Thank you, Sir Peter.
Sorry, what page?
At section 45, your Lordship will see in subsection 2.
What page, please?
1117. Your Lordship will see at subsection 2 a condition set by Ofcom under this section must be either a general condition with which we are not concerned, or a condition of one of the following descriptions. 1A, 2 is an access, what they call an access-related condition. So that is the starting point of the UK transposition. That it has to be an access-related condition. That term is then more specified over the page at section 45, subsection 5, at page 118. And subsection 5 says an access-related condition is a condition which contains only provisions authorized by section 73. So that is what Ofcom can do, insofar as it's relevant to this appeal. It can impose an access-related conditions, which means only conditions authorized by section 73. So we now have to go forward to section 73 to see what those are, and your Lordships will find that at page 1121. And subsection 1 says that the only conditions that may be set under section 4, access-related, under section 45, as access-related conditions are those authorized by this section. And then subsection 2 says that access-related conditions may include conditions relating to the provision of such network access and service operability as appears to Ofcom to promote the regulatory objections, to paraphrase. And then over the page at 1122, at paragraph 74, at the bottom there, the conditions that may be set by virtue of section 73.2 include conditions which, for the purposes of securing end-to-end connectivity for end users of public electronic communication services, provide, and there your lordships will recognize some of the language from little a of Article 5. Over the page at subsection 1a, the conditions may be set. The conditions that may be set by virtue of section 73.2 also include conditions which impose such obligations on a person controlling network access to customers. Your lordships will recognize that as little ab. Subsection 2, the conditions that may be set by virtue of section 73.2 also include such conditions imposing obligations on persons providing facilities for the use of applications for program interface television stuff. Your lordships will recognize that as little b of Article 5. And the rest of the list in section 74 are the new lists, the new items added to the list by the ECC. So over the page, 3 or 4 pages worth, taking your lordships to page 1125, all that stuff is still and to the end, and that is it. And then your lordships get to section 75 on page 1127. Sorry, not 1125, 1127, and your lordship will then see the heading "Conditional Access Systems to Digital Services," which your lordship may have picked up already, is Article 6. So, network access means let me just, your lordship, if your lordships return to page 1131, section 151, which is the interpretation, again, there's a definition there of access-related conditions, means a condition set as an access-related condition under section 151. And then in section 153.3, on page, no, it's 1513, I beg your lordship's pardon, 151 subsection 3. On page 1134, where section 73 has limited the access-related conditions to network access, it then says what network access are references to.
Sorry, the reference again, please, Mr. Peter.
Section 151, subsection 3, on page 1134. Given that section 73 and 74 limit the scope of access-related conditions to access to networks, and your lordships will understand that this is perfectly germane also to ground 2, but we're on ground 1 now. In this chapter, references to network access are references to interconnection of public electronic communications networks. B, any service facilities or arrangements which are not comprised in interconnection but are services, facilities, or arrangements by means of which a person is able, for the purposes of the provision of electronic communication services by him or by another, to make use of anything mentioned in subsection 4, and references to providing network access includes references to providing such service, making available such facilities, or entering into such arrangements. So now you've got to go to subsection 4 to see the things to which the definition applies. And subsection 4 says the things referred to in subsection 3b are any electronic communication network or electronic communication service, so access to the network or to a service, any apparatus comprised in such a network or used for the purposes of such a network or service, any electronic communications apparatus, any facilities made available by another that associated facilities, let me read it again, any facilities made available by another that are associated facilities references to any network or service, and that is to accommodate the fact that something doesn't cease to be part of your network or part of an associated facility of your network because you don't own it, and you acquire it by lease, borrowing, permission, or whatever from somebody else. And any other service or facility which are provided or made available by any other person or are capable of being used for the provision of an electronic communication service. So your lordships will see there, and that's the whole of it. Your lordships will see there how the UK's transposition is, despite the width, such as it is, of the definition of network access, is still focused on and limited to things that allow you to gain access to a network for the purposes of gaining access to a network. It's got to be networks or associated facilities, and there is no power from this definition, from these definitions, there is no power in Ofcom to order access to things that are not related to a network or network facilities, or are not for the purposes of reaching a network or its facilities. And that would exclude Ofcom from being able to do what the Court of Appeal has said the GRA can do, which is to say, let them into the data center because it is a building, and the definition of access refers to buildings. So moving on, given the shortness of time, my lord, rounding all that up in just 3 lines, what I've invited your lordship is, on the basis of my submissions and the validating authorities that I have been able to offer your lordships, is to interpret the first subparagraph of paragraph 5 of Article 5 as meaning that the references to where appropriate ensure in accordance with this directive. The words where appropriate means something. When is it appropriate in accordance with this directive? Not in every case, otherwise the word appropriate would not be required. The word appropriate must point to something, as does the words in accordance with this directive. And we're asking your lordships to accept our view that it means, but if your lordships take a different view, then the GRA will certainly enjoy exercising their power, as a road sign that points to Article 4.1, it points also to Article 8, and it points, as one of your lordships asked me this morning, it points due south to the second paragraph of Article 5, that is A, B, and B. And the GRA believes, subject to your lordship's view, that that is the proper interpretation of this provision, and shared by those other authorities that I have mentioned. So where then did the Court of Appeal go wrong? If your lordship turns to their judgment at page 16 of the bundle, That should be paragraph 20. Sorry, my lord, I don't seem to be able to lay my hand on it, but I've got the text. Paragraph 20. His Lordship, Lord Justice Elias, with which the other two members of the court agreed, said it would make no sense for the GRA to determine that the same duty arises by virtue of Article 5 or for it to be asked to do so. Now, I don't know what he means by saying it would make no sense. Does he mean that he doesn't think the power exists, or does it mean that it exists, but no one will be foolish enough to ask the GRA to exercise it? If it's the latter, that isn't really good enough. That you can't. I don't believe that you can interpret the scope of legislation on the basis that no one is going to be silly enough to test it. The relevance of Article 5, in my judgment, is that it might justify the imposition of an access duty in circumstances where there is no equivalent access in place pursuant to Article 12. But he comes head-on against the second paragraph of Article 8.3, which says that that's exactly what he can't do to an SMP operator. This might be either because the operator against whom the duty is sought to be imposed does not exercise SMP in the relevant market. So in the case of a non-SMP operator, we say that's wrong too, because it's limited to A, B, and B, and it's not a general. The in particular doesn't open the door to everything and anyone. Or because the nature of the access sought does not fall within the scope of the access which may be imposed under Article 12, and that's again the breach of last paragraph of Article 8.3 point. And this is where his Lordship, if I am right, started to go wrong. And then in paragraph 45, building on that error on the part of one of us, he said the second submission is that the power to order access arises by another route, namely the power under Article 5. When read with the definition of access in Article 2, for the GRA to require access to physical infrastructure includes buildings, ducts, and masts, Mr. McLean submits that GFS can bring itself within the access category, simply on the meaning of what the word access means in the definition of it. The judge below seems to have taken the view that if GibTel has SMP, it cannot be subject to Article 5 access requirements, because this would allow Article 5 to be used to subvert the strict procedural requirements of Article 12. But of course, if I'm right on Article 8, last paragraph of Article 8.4, my lords, then the judge below, namely Mr. Justice Butler, was right, not wrong, to take that view. And then Lord Justice Elias says, I see the force of that. The force of that presumably means that he thinks he's right. It's not clear what he means by seeing the force of it. I see the force of that where the access in question is to elements of the network and associated facilities, in other words, the Article 12 possibilities, because it then replicates the access obligations which can be imposed under Article 12. But where the access sought is of a kind which cannot be imposed under Article 12, I cannot see why an SMP operator should not be subject. Pause there. The reason why it can't be subject is because of the last paragraph of Article 8.3. Why an SMP operator should not be subject to the same requirement as a non-SMP operator. But that jeopardy is not incurred in, because the non-SMP operator is not either exposed to it. So this is not a question of the last paragraph of Article 8.4, protecting an SMP operator from that against which a non-SMP operator can be exposed. It's because the non-SMP operator cannot have it applied to him either, unless it's within A, B, and C. And if the answer is that it can be, then it can also be imposed on the SMP operator under Article 12. And the purpose of A, B, and C, and the second subparagraph 5, is only to allow that to be done to non-SMP operators, despite the prohibition against that in Article 8.3. Indeed, it would be curious, and we say, well, the curiosity does not exist, if its SMP status meant that it was subject to a less rigorous regulation than a non-SMP undertaking. That's not the case. If it is appropriate to require adequate access to promote sustainable competition under Article 5, and that access cannot be imposed pursuant to Article 12, I see no reason why, in principle, it should not be imposed, notwithstanding that the operator has SMP in the relevant market. Last paragraph of 8.3, and coach and horses through the whole SMP framework. In other words, what he says, if in the name of competition, it ought to be applicable under Article 5, even though it can't be under Article 12. So, my Lord, that is where we think the erroneous outcome is anchored in. His Lordship and my learned friend are in the same place. I believe I'm in the same place as Lord Sumption in the House of and the Supreme Court, Telescenaria, and the European Commission, and the textbook writers, and the draftsmen of the UK legislation, and those members of the Commission that have chosen not to infract the United Kingdom for the way they've transposed the legislation. And therefore, I believe that the GRA is entitled to succeed on ground 1, and I would invite your lordships to allow the appeal. Ground 2 is a good deal simpler, my lord, and I hope to be able to rattle through that quickly. Not least because I know that my learned friend, Mr. Palmer, is going to be addressing your lordship on that. So this is basically, put at its most simple. The rest of it is just authority for this proposition, I suppose. A piece of subsidiary legislation cannot impose power which is outside of its scope. I suppose Parliament, in the exercise of its sovereignty, can. I don't know whether an Act of Parliament that said it was limited to such and such a scope and then tried to give a power outside of the scope, raises interesting questions. That might be the case in the name of parliamentary sovereignty in the UK, but certainly Parliament in Gibraltar does not enjoy that degree of sovereignty. And in any case, we're not in the realms of primary legislation, we're in the realms of subsidiary legislation, the access regulation. And the fact that it's outside the scope of the articles, I think, is moderately clear. When a piece of legislation goes to the trouble of defining its scope, to say that it doesn't purport to define its scope and is simply a high-level statement, I think is an unbridgeable gap of logic. The directive itself says that is its scope, as indeed does the Act. And I think, in a nutshell, my submission to your lordship would be that that is that on ground 2. So, their lordships down below, having found... Sorry, I don't know if someone's trying to interject. Yes, the blue line is round, although I can't hear anybody.
Is your submission based on Article 1? You didn't identify what that is.
Yes, I am going to now go to those, my lord, just briefly, because they're all there. The access regime in the regulatory directives applies, quote, to access to and use of, just by the title of it, access to and use of specific network elements and associated facilities of the requested parties' electronic communication networks, or networks and associated facilities. Now, the scope of the directive itself, which is stated to be limited to access to and interconnection of, this is Article 1.1 at page 603, my lords. I'm sorry, I should perhaps have taken you to the page number first. So that is page 603, Article 1.1 of the Access Directive, which states that it is limited to access to and interconnection of electronic communication networks and associated facilities. I should add there, entirely consistently with the UK draftsman's view, given the way that he has circumscribed the access-related conditions in Section 45 and Section 73 and 74, and in the definition of network access in Section 151, subsection 3, to precisely things that give access to electronic communications networks and associated facilities. The Act itself, that is to say, the structure in Gibraltar, I haven't taken your lordships through this, although it's in my written case. So the Framework Directive itself was done by primary legislation, our Communications Act, 2006. And then the other directives were done by a set of regulations. So we have the Communication Act transposing the Framework Directive, and then in the case of access, the access regulations transposing the access directive. Well, Section 2.2 of the Act, reflecting the Framework Directive, provides that references in this Act to access in relation to any electronic communication network or communications service are reference to the opportunity of making use of the network or service. And it really would be quite pointless for the legislature to have said that, if in fact access in other contexts means anything that fits under the 15-line definition of the word access in the definition of access. And that's at page 843, my lord, section 2.2 of our Act, section 2.2 of our Communication Act. Section 34.5 of our Communication Act, which is at page 865, section 34.5, imposes the obligation on the GRA to ensure that there is open and efficient access to and interconnection of public electronic communications networks. Garziniti, at paragraph 1-229, which your lordships may have in their separate little paper bundle. Would they have? What is this? 1, 3, 4, 6, maybe in the electronic. No, it's in the electronic. I beg your pardon, your lordship. In the electronic bundle, 1, 3, 4, 6. At paragraphs 1-1229, yes, says in particular, the Access Directive provides a regulatory framework containing the general principles relating to the provision of access to and interconnection of networks for the provision of electronic communication services. Now, the access requested in this case, and on appeal to your lordships, is completely outside of that. I don't know if your lordships, I should perhaps have made this clear to your lordships, that what the access requested involves getting into the data center, the respondent with his own network, placing his own servers on racks in the data room, in the data center room, connecting his network to his own server, and then connecting his own server to the customer servers. In other words, going nowhere near and making no use of and not interconnecting with or accessing either GIB Telecom's network or any associated facility of GIB Telecom's network. And that is why the GRA believes it is helpless to help them. And that is why the Court of Appeal turned down the Article 12 appeal, because the Court of Appeal agreed with Mr. Justice Butler and the GRA that the access requested did not involve a request for access to network or any associated facility of GIB Telecom's network. Moving on then at paragraph 1-230.
I should just point out to you, Sir Peter, that you're now beyond your allocated time, and I'm not going to stop you, but it will come out of your reply time.
Okay, my lord. I'll just say, make one more point in respect of this matter. The essence of the submission is there. There are more illustrations of authority in my written case, but there is one point that I must deal with. My learned friend's entire case around this depends on the fact that in the definition of access, there is a reference to network associated facilities, and then it goes on to talk about other buildings and things. And he says, ergo, if the definition of access is networks, associated facilities, and other buildings and infrastructures, the other buildings and infrastructures must add something to networks and associated facilities. That is correct, but doesn't avail him the purpose that he requires and puts it for, because it is not, and indeed misses the point, because it is not that the access has to be only to the network itself, or only to the network's associated facilities. It is that the purpose of the access must be to access the requested party's network or associated facilities. And that access may well involve access to infrastructure that is not included in network and associated facility. But it must still be, the access requested would still need to be access to the requested party's network or facilities. Now, not to something that is not for the purpose of and does not reach, and is not intended to reach, as is our case, the requested party's network or associated facility. And your lordships can pick up this from from page 1354. Just to give your lordships an example before I take him to what Nehud and Rodwell says about this. I mean, my network could reach a building and a part of my building, and another network operator may wish to access my network through some part of my building through which my own network does not reach. So he wants to come into the building by another route to connect to my network or to access my network, but by ducts that approach the building perhaps from a different geographical direction. That would be what those other references to infrastructure and the access are. So the requesting party wants to access my network, wants to interconnect with or access it, but wants to do it through buildings of mine, buildings, ducts, or anything else that is in the definition of access, which don't themselves support my own network, because my own network enters the building by some other route. And if your lordships turn to to the page 1354, and then I shall leave this ground. Your lordships will see an extract there from Rodwell, Nehul and Rodwell, which is the other.
I'm sorry, Sir
Peter,
could you give us the electronic page reference again, please?
1354.
Of course, my lord, 1354. And your lordships will see at paragraph 3, internal to the book, 3.31. Does your lordship see a sentence that the heading is access to physical infrastructure? And it says access to physical infrastructure. First, access must be granted to network or network elements. This entails access to physical elements of infrastructure. As an example, providers or operators may ask for access to ducts in which lines or wires are placed. used for transmission of communications over fixed or mobile networks. Another example, and this is the sentence I'm pointing out to your lordship, another example is access to buildings where this is required to connect with the network. Not access, this is what I've been explaining to your lordship, not access to a building not to connect with another network, access to a building to connect with the requested party's network. And that's exactly the point that I've been making to your lordship. And therefore, my learned friend cannot rely on the definition of access to argue that under the Access Directive, it's within its scope to allow access to buildings when he doesn't want access to my network, because the scope properly explained is access to physical infrastructure in order to gain access to the requested party's network. And the access requested by GibFibre Speed in this case singularly seeks to avoid access to Gib Telecom's network, and the Court of Appeal has found that nor does it seek access to any of Gib Telecom's network's associated facilities. So, my lord, leaving it at that, so as not to take up all of my response time and giving my learned friend a free pass. Although,
so Peter, just before you leave that, could I ask you one question about the definition of access in the Access Directive, page 604, Article 2A? As I understand it, your submission is that the definition of access there has to be read subject to a purpose requirement, that it's access for the purpose of gaining interconnectivity with another network.
That it's access, that it's access to something that is...
My question is that the definition of access seems to build in expressly the purpose for which access is required. It's for the purpose of providing electronic communications services. And I'll just invite your submissions as to how that express purpose requirement lives alongside what I understand you to be putting as an implied additional purpose requirement.
All that means, my lord, I'm grateful to your lordship for the question, all that means is that the requesting party must want the access to my network, to the requested party's network, for the purpose of him providing electronic communication services. The definition of access doesn't itself establish the scope of the directive, and therefore doesn't determine the purpose to which the definition can be put. The scope, so access means access in the context of the phrase access to network or or associated facilities. And the requested parties must want to do two things. He must want access to the requested party's network or associated facilities, because that is the scope of the Act, as Nehur and Rodwell says that. And he must also want it for the purposes, not for the fun of it, but he must also want it for the purposes of he himself providing electronic communication services and not for some extraneous purpose. And that is the significance of the words to which your lordship has just pointed.
Yes, thank you.
My lord, the point about article, the point in very few minutes, because the point about article market 4 is that it relates to stripping it of its unnecessary adjectives and alleys and byways. It refers to wholesale network infrastructure access at a fixed location in Gibraltar, including shared or fully unbundled access. And the GRA believes and has issued notices on the assumption of its belief that this is limited to what is colloquially called the local loop, sometimes referred to in newspapers as the last mile, historically delivered by a pair of twisted copper cables, now bridged sometimes by fibre. And that is a defined term under the Act. What the local loop is defined under the Act. It's defined in Article 2E at page 605. And the GRA believes that the local loop, and my learned friends' clients acknowledge that they don't seek access to the local loop, so the question is not whether they're seeking access to the local loop. The issue in dispute here is whether Market 4 is limited to the local loop or is not limited to the local loop and extends to something to which my learned friend's client is seeking access. Because that would be necessary to make it a relevant market for the purposes of SMP by the requested party GibTel. Now, the GRA believes that that is not the case, and there are all the matters to which I have referred in my authorities listed at paragraph 36 of my bundle and of my written submission, set out in the page numbers of the bundle, stated there in the sub-paragraphs of 31, are to the effect that Market 4 is still thought of by everybody as limited to the local loop. I'm just, because of the shortage of time, I'm not going to refer to all of them. If your lordships are minded to, perhaps they might look at that. But I'll refer to them, to the key ones, which is at 33.7, which is a report by Ecoris, a specialist telecommunications consultant, dated 18th of September 2013, and I'd like your lordship to turn to internal page 110 of that, which is on page 1372 of your lordship's electronic bundle. And at the bottom there, local or physical access, market definition, and competitive assessment. Traditionally, local loop takes the form of physical access to the unbundled twisted copper pair. However, as technology progresses, virtual alternatives to physical loop access are emerging. The regulatory framework requires that relevant markets should be defined in technologically neutral manner. This is the distinction between copper and fiber. Within the first market recommendation, Market 4 2007 was defined as wholesale, unbundled access, including shared access to metallic loops and subloops for the purposes of providing broadband and voice services. In view of the increasing development of other access technologies, the term metallic loops became outdated. Consequently, within the 2007 recommendation, which is the one reflected in the decision of the GRA on SMP, is defined in a more technologically neutral way as physical network access infrastructure, but only because of the difference between fiber and metal, not because it's speaking about something else. We will revisit the question to what extent this definition remains technologically neutral today and in the coming years in the next section. Due to the aim of technological neutral market definition, one of the most important questions for the definition of Market 4.7 is what type of technologies can be included. So far, only copper and fiber-based local access have been included in Market 4. And if your lordship could come forward to page 1374, so your lordships may know that this market identification process that has to take place by the Commission under the framework, Article 16, the SMP procedure, this is a table which compares the markets as they have evolved. So the first one was in 2003. Your lordship, halfway down the table, your lordship will see market 11 in the second column on the left. And that was called, the first recommendation was local loop unbundling. It was called market 11 in 2003. It became market 4, which is the one we're now concerned with in the Commission's 2007 markets assessment recommendation, and it's still known as local loop unbundling, as your lordship will see from the column on the extreme right. And the tables on the previous pages that I've not taken your lordship to, at page 1371 and 1369, other tables, exactly the same point. Market 11 is described as local loop unbundling, and market 4 is described as local loop unbundling. And therefore, market 4 remains local loop unbundling. And this is confirmed at page 1375, and this is my very last utterance to your lordships. At page 1375, market 4, halfway down the second paragraph that starts there, market 4 deals with the second highest rung of the investment ladder, whilst the highest is full replication. It refers to the local access or the local loop in traditional term, which links an end user's premises and the local exchange, the traditional last mile. Local loop is considered to be the least replicable element in the establishment of an access transmission channel to an end user's location, is local access to the local loop. Then there are 3 lines there which I don't think are relevant. Then access to local loops can take different forms, such as fully unbundled, where traditional telephone services is also unbundled, partly unbundled, or shared access, where only data service is unbundled, and unbundled subloops, where part of a local loop is unbundled. This is a question of bundling, and unbundling is a question of capacity that you take in somebody else's local loop. Can you put down whatever you like, or can you only put down the same services as the network, as a last mile owner is putting down? It should be noted that unbundled local loop also includes unbundling associated facilities. In other words, the local loop can also give you access to associated facilities as well as to the network itself. And therefore, my lord, it's on the basis of those indicate the GRA's view, those indications, as well as some indications by the Commission itself in the listed authorities that I have not had time to cite to your lordships, that led the GRA to believe, and they continue to believe, that market 4 is limited to what you and I might still call the last mile, and that the last mile, the local loop, goes nowhere near the data center, and therefore cannot be engaged by the access requested to the data center, and is therefore not a relevant market in which GibTel has SMP for the purposes of the access request. I'm obliged to your lordships for allowing me a few more minutes now to finish.
Thank you very much, Sir Peter. Mr. Palmer.
My Lords, I'm going to spend my 30 minutes by concentrating on ground 2, including responding to some of the points which has been made in my learned friend's written case and his response to my written case. I'm going to endeavour not to repeat what I've already said in writing. My Lords, in my submission, the central point, the beginning and indeed end of this case is ground 2. And the 10 minutes or so that my learned friend, Sir Peter, spent on it towards the end of his submissions, I can adopt as being, in my submission, entirely right. The central point in this appeal is that GibFibre seeks to place its own server in a data center, not to interconnect with Gib Telecom's network or any element of it or any associated facility or service, but to connect directly to third-party customer servers which form no part of either Gib Telecom's electronic communications network or indeed any other. And my central submission is that ground 2 of this appeal should be allowed because such a request falls outside the scope of the access regime altogether. Now, the reasons for the GRA's decision, the decision which is under appeal, are conveniently set out in its letter to GibFibre, dated the 16th of February 2017. I'm not going to turn to it now, if I may. I'm going to give you the reference. It's at EB 199, and it's paragraphs 17 to 30 of that letter, which Gib Telecom respectfully submits is wholly correct in the analysis. It makes this scope point, in short, and in particular the conclusion that the requested access falls outside the scope of the access directive. And it's that passage which I say is entirely right and provides a complete answer to this appeal. The only basis upon which GibFibre can request regulated access under the directive, as opposed to independently commercially agreed access like Sapphire Networks have done, is to seek access to Gib Telecom's publicly available network by means of the purchase of wholesale access services provided by Gib Telecom over its network. That is what the access directive provides for and is all about. It is quite different in substance to what is being requested here. As I've laid out in writing, I don't intend to dwell, but there are two central limitations on the scope of the access directive, two distinctions which I draw to the court's attention. The first is the distinction between wholesale services and retail services. And the second is the distinction between access to public communications networks and non-public networks. And my submission is it's quite clear that the access directive is only concerned with rights of access to wholesale services. It's not concerned with rights to provide a retail service directly to an end user over your own network. It's about purchasing a wholesale service from another network provider to provide a service over that to reach an end user. And secondly, it's limited in scope to the publicly available network, not any private network which lies beyond what is called the network termination point, which marks the limitation, the limit of the publicly available network. It's the point at which the end user gets access to that publicly available communications network. What is being sought by this request is not even a request of access to a private network or the non-public part of the network. It's a request for access directly to the third-party customer, not touching Gib Telecom's network, public or private. But nonetheless, those are the two limitations of scope inherent in the access directive. Let me just make that good by reference to the directive. I'm going to go to Article 1, which starts on page 603, entitled Scope.
Just before we go to it, can I just ask you, I may be exceptionally ignorant, but I don't really have a very clear idea of what these servers, of how these servers work and how they are connected up to whatever they're connected to. The only server I've any experience of is a server I have at home. Now, that server is connected to a public communications network, and it enables everyone in the house to access that network from computers and phones and other devices in the house. Now,
it's likely to be a router. I don't know, of course, my lord.
Well, that's what I'm thinking
likely to be a router rather than a server.
I'm thinking of a router. I'm displaying my ignorance. Please explain to me what exactly this server is and how it works.
A server, first of all, physically, it's typically a box about that big, which is stored on racks, one above the other. What it contains is a storage of data which can be accessed over the internet, over electronic communications services. So to take the example you were given earlier of gambling, online gambling services, the real work that is done when someone goes onto the internet and places a bet or plays a game is done inside that server. That's where the computing operation is happening. And to provide a link between that server, which is housed in a data center, and the user, wherever he or she is in the world, accessing it on the internet, that user obviously goes through a publicly available electronic communications service network to the data center.
I'll ask you to pause. We seem to have lost Sir Peter. Right, we can resume.
So a data center is essentially large rooms with a lot of racks in. On each rack, a lot of servers, all generating a lot of heat, all consuming a lot of power, needing the temperature to be controlled quite intensively, needing that power to be provided as well as backup power sources. Should there be a power cut, they have their own generators, their own power sources, needing to be kept in a very secure environment because you have competitors in the same business, within the same data center. Their customer servers need to be entirely separate and kept secure away from other customers. So no accidental damage could be done by one customer's engineers to another. So it's quite an elaborate setup. It requires, as I said in the written case, quite substantial capital investment, millions of pounds. And to answer the question that you asked right at the outset about the commercial incentive, it's a big investment. If an operator like Gib Telecom makes such an investment, it's on the basis that it's going to recoup its investment by, firstly, renting space in the racks to its customers, and secondly, providing communication services in and out of the data center to and from that customer server. It does that by wiring all the servers up through rather complicated distribution frames which allow the wires to be kept in order so that when someone unplugs or plugs something in upstairs, they know which server it's going to affect downstairs. That requires a lot of logistical organization, that internal cable network. So those cables come out in what is called the carrier room, which is where the routers and servers which are designed to provide that communication service picks up the data from the servers in the customer racks, communicates it, sends it off on its way over the publicly available telecom system to wherever its destination is, and similarly receives signals back and channels it back down to the right server in the right customer room. So that is where the network termination point will be found, at that carrier room. There can be argument about precisely where you locate the network termination point. There's room for regulatory judgment as to where that is. But
sorry, if I just pause there, just to make sure I've understood you so far. The servers are essentially very powerful computers which are connected to an electricity supply and are housed, as you've explained. And then there's internal wiring provided by
Rocolo in this case,
by Gib Telecom to another room where Gib Telecom's server is. Is that right?
That's right.
And from that point, you access from the server. You access the public telecommunications network that Gib Telecom operate.
That's right. That's it in a nutshell. And similarly, Sapphire have their own room, and so customers can choose to go either to Gib Telecom's room or to Sapphire's room. And if they change their mind, it's just a question of unplugging something, plug it in the distribution frame, which organizes it, so they can choose which provider they want. The reason why it's in Gib Telecom's commercial interest to invite Sapphire in as well is that many customers want to have both for reasons of what's called resilience. If one network goes down, they can continue serving their customers all over the world without interruption. So it is a positive attraction from Gib Telecom's point of view to be able to offer another provider services inside the data center. It's reached those terms on the basis of commercial negotiation. We say that doesn't in any way suggest there's a regulatory obligation to invite all and every communications provider who would like to come in, because that would then risk undercutting the very commercial basis of the investment in the first place in that multi-million-pound data center. So
so as far as GibFibre are concerned, are they wanting to connect their network into the did you call it the distribution framework?
No, the request they made is to go straight into the customer suite and to connect, place their server on the rack next to the customers they want to serve, and just bypass the whole of that internal wiring structure and just take that custom straight out of the customer suite. That's the basis. You'll find that recorded as common ground, paragraph 37 of the Court of Appeal's judgment. It's page 25 of the bundle.
Mr. Palmer, could I ask, you've talked about the network termination point. Is that a defined term, or is it?
It is.
It is. All right. Okay.
I'll take you briefly through it in a moment, if I may. It's in the defined in the Framework Directive, and it is also defined. The publicly available communications network is defined by reference to network termination points. Now, there may be.
Can I persist with my obtuseness? You've explained what a server is. If GibFibre place what does their server do?
It provides the communication service, if you like. It's what makes the data leave the customer's box and sends it off over GibFibre's own network down its fibres to the next port of call, which will be another server located off-site somewhere else in GibFibre's exchange, wherever that is.
Right. So by placing their server there and connecting their server to the other customers' servers, they would be providing their communication service to all of those servers, and it would have no connection with yours or Sapphire's.
Exactly right.
Is it a sort of very sophisticated telephone exchange then, the GibFibre, the Gib Telecom server? Because it's directing things coming in from outside to a particular server and likewise directing signals back from that server.
Yes. I should make clear it's not just one server, it's banks of servers because the volume of traffic to service all these, there's loads of them, but they're all performing that function. And that could be around the world. There's undersea cables which go through Gibraltar and cross continents. That's how it works. You need those servers to program, if you like, the route to tell the data where to go and to get it there.
And that's what GFS would do if they connect direct to the customer servers. In effect, they would substitute their own server, presumably, to do the same function.
Exactly right. And the basis upon which they asked to do that was to put their server in the rack and connect directly to the other servers, and bypassing Gib Telecom's network altogether. In the written response to my case, my friend has developed that a bit and say all we want is to be treated the same as Sapphire, and we could have our own carrier room, so we could still use the internal private wiring through the Roccolo, the data center distribution frame. I say that makes no difference at all, because you're still only using the private bit of the network beyond the network termination point, and the network termination point would still be on GibFibre's own network and not be entering Gib Telecom's publicly available network at all, just by definition. So it doesn't matter where you place that box within the data center. The point upon which I rely is what is being done is to bypass Gib Telecom's public network entirely and provide a direct retail service to the customer.
Yes. Now, I've taken you off your submissions for the last at least 5 minutes, but it's been invaluable. So we'll allow you to carry on beyond your allotted time to make up for that.
Well, I'm very grateful for that. So I was just about to go to Article 1 of the directive, just to explain that. Entitled Scope and Aim, my submission paragraph 1 is more concerned with explaining the aim. But that includes, of course, the words access to and interconnection of electronic communications networks and associated facilities. I'll come to the definition of associated facilities shortly, and then the aim follows. 2, it is directly concerned with scope and includes the 2 important limitations, which I have outlined to my lords. The first sentence of 2 is this directive establishes rights and obligations for operators. Just emphasise that word operator. I'm going to come back to that because it's separately defined.
You're reading Article 2.
Article 1.
Article 1, 2, sorry.
I'm sorry, Lord. I'm at the top of page 604, Article 1, paragraph 2. First sentence, rights and obligations for operators, I'll come back to that word, and for undertakings seeking interconnection and or access to their networks or associated facilities, the word their refers back to operators. Operator is defined in Article 2C, the same page. It means an undertaking providing or authorised to provide a public communications network or an associated facility. So that is where you find the public limitation coming into the scope, because it concerns the rights and obligations for operators who must, under the terms of the directive, provide access, to the extent mandated by the National Regulatory Authority, for undertakings who seek that interconnection and access to that operator's network or associated facilities. And the second limitation you find in the final sentence: access in this directive does not refer to access by end users, because end users' access to such networks is by way of a retail relationship. This is you or I have a home contract with BT or whoever. The access directive, our ability as customers to access these networks, is not the subject of this directive, which is concerned with relationships between operators and undertakings themselves. You find both of those points echoed and supported in Recital 1, which is on page 597, which is, this is well established, an aid to interpretation. And it's the final three sentences, beginning 7 or 8 lines up from the bottom of Recital 1. The provisions of this directive apply to those networks that are used for the provision of publicly available electronic communications services. So that picks up my point about operators. And then next, second last sentence, this directive covers access and interconnection arrangements between service suppliers. I might say because operators are service suppliers themselves as well, of course, but that's the wholesale nature of the scope. And then returning to the public-private distinction, or non-public networks do not have obligations under this directive, except where, in benefiting from access to public networks, they may be subject to conditions laid down by member states. Now, my learned friends pull that sentence and says in some way that supports him. In my submission, that is wrong. It doesn't support him. What that is about is making clear that private or non-public networks have rights to access or interconnect with public networks, not the converse. So if you're a non-public or private network, in order to communicate with the rest of the world, at some point you're going to have to interconnect with a publicly available network. And conditions can be laid down. Those conditions could involve the costs of interconnection, could involve compatibility of equipment, but those are to be laid down by member states. And you won't find those conditions being provided for anywhere in this directive. What my learned friend wants to do is to turn this around and says, this supports our submission that we, GibFibre, a public communications provider, can seek access to this private network or even direct to the end user itself. So that's beyond the scope, and that qualification doesn't help.
Is the reference to subject to conditions laid down there conditions by which they are entitled to have access to the public network? So I'm not quite sure how it would work, but could a regulatory authority say, well, yes, we'll require that you have access to a public network, but on payment of reasonable fees or something like that?
They could say that. They could also put down certain conditions as to compatibility of equipment and signals and so forth to make sure it doesn't cause any kind of disruption to the public network. But that would be for member states to lay down directly. You won't find those conditions provided for.
But that's the sort of thing.
That's the sort of thing
you say that
yes.
word conditions yes. refers to.
It does. It does. But my main point, my lord, is this is about non-public networks getting access to the outside world, getting access to public networks, not the other way round, which is what is being sought by my learned friend.
Yes, thank you.
Now, my learned friend's main submission is, well, you can't stop there. You have to go on to Article 2 and look at the definition of access, which is actually much broader, he says, than what I've just outlined to you. Well, that is incorrect in my submission. Article 2 is on page 604. My lords have seen it. Let me first of all accept straight away it is a wide definition. But the key point here is so is the definition of network elements and elements of the network, and in particular associated facilities. In a moment, I'm going to just ask you to look at and to turn backwards and forwards between the definition of associated facilities, which my lords will find in the Framework Directive. But the conclusion I'm going to ask you to draw in a moment is this is an intensely duplicatory definition. It could have stopped with the words access to network elements and associated facilities without loss, for reasons I'll show you in a moment. But what the legislature has chosen to do is to emphasize the breadth of the definition, even at the cost of repetition, to remove any doubt as to how all-embracing its approach is in terms of access to networks and associated facilities. I want to show you what I mean. If you keep a finger in Article 2 of the Access Directive, but turn forward to the definition section of the Framework Directive, which is at page 632. And my lords may have seen, I should make this apparent if it's not obvious, the first sentence of Article 2 is that for the purposes of this directive, the definition set out in Article 2 of the Framework Directive shall apply. So one looks at the Framework Directive for the definition of these terms. 632, my lord. You will see there at A, the definition of network. For reason of time, I won't dwell, but it's the transmission system over which services are provided. Then the definition at C of electronic communication service, which is a service provided wholly or mainly in the conveyance of signals on networks. Then at D, public communications network, wholly or mainly for the provision of electronic communications services available to the public, which supports the transfer of information between network termination points. This point is an answer to Lord Sales' question earlier. Then DA, network termination point, is then defined. So you'll see the physical point at which subscriber is provided with access to the public communications network. Subscriber is then defined at K, and they didn't dwell on that. End user is defined at N, just for your note. But then associated facilities is defined at E. I just asked the court to concentrate on the breadth of this definition. First of all, it means those associated services, pause there. Associated services are separately defined in the following subparagraph EA, so I'll come back to that. But those associated services, physical infrastructures and other facilities or elements associated with a network and or service which enable and or support the provision of services via that network and or service, or have the potential to do so, and include, inter alia, so non-exhaustive obviously, buildings or entries to buildings, building wiring, antennae, towers, supporting constructions, ducts, conduits, masts, manholes, and cabinets. And then I remind it, this included associated services, which is then amplified in the next subparagraph. Those services associated with an electronic communications network and or service, which enable and or support the provision of services via that network and or service, or have the potential to do so again, and include, again, inter alia, number translation or systems offering equivalent functionality, conditional access systems, and electronic program guides, as well as other services such as identity, location, and presence. So all of those things are bound up within the definition of associated facilities. So when one talks about access to a network, you're talking about all the elements of the network, plus all of these associated facilities which in some way support it, non-exhaustively, or have the potential to do so. That's what the word associated facilities mean. If you go back to the definition of access, which as I said, it's fully accepted broad, there is nothing in it at all which doesn't fall within the definitions of network and associated facilities. Indeed, it repeats not just the words physical infrastructure, including buildings, ducts, masts, but also the rest of it: access to relevant software services, access to number translation or systems offering equivalent functionality, you'll remember from the definition of associated services, access to fixed and mobile networks, so back to network, access to conditional access systems for digital television. Again, you'll remember that from the definition of associated services. Now, the logic of the court below, and Sir Patrick Elias's judgment, was to say at paragraph 50, well, this must be there to add something. It can't simply just be what's already included in network elements and or associated facilities, because otherwise it's OTOs. In my submission, that's an error and a misunderstanding of what the legislature is trying to do. Because if it's talking about some other buildings, for example, to take physical infrastructure, it's talking not only about buildings which are not used in any way to support the network, but also talking about buildings which don't even have the potential to do that. It's talking about another class of buildings altogether, seems to be. And the same logic would presumably apply to things like conditional access systems or number translation, which is just unreal. What in fact the legislature is doing is really just bringing forward much of what is already set out in the framework directive to emphasize the policy intent, which is that within the scope of this directive, i.e. access to public communications networks and associated facilities, it wants to cover everything non-exhaustively. Again, it's inter alia, making clear anything else which can be wrapped up in these very broad definitions. But it's not opening another category altogether of some other property or some other property which happens to be owned by the provider. That would
only the definition anyway of the word access.
Yes.
And you've still got to read access to what?
Access to what? Exactly.
And it's only to the what that the definition applies.
That's right. So my central submission from my lawyer to space is this has to be seen not as enlarging the scope, as my own friend would have it, but as sitting within the scope of the directive as I've explained it to be. And so if you're in scope, well then, yes, the definition of access is very, very broad. But what my learned friend wants to do is say you can leap from that really to widen the scope beyond access to another provider's network or associated facilities and go straight to the end user, which I say is entirely impermissible and out of scope under the Access Directive.
Yeah, so that's, I mean, in a nutshell, you're saying that that GibTel are providing a service by enabling customers to keep their servers in this room under special conditions.
Yeah.
But it's not part of or necessary for their electronic communications service.
Well, it's for GibFibre's electronic. They want to obviously provide an electronic communication system over their network, but as the Court of Appeal rightly held, and there's no cross appeal on this, those servers in their racks do not form part of GIB Telecom's network or associated facilities. Yeah. I say that's killer. That's the end. My own friend says no, Article 5 can go beyond that because look, the definition goes beyond that to physical infrastructure, which must mean something else, and this is physical infrastructure. But here's the next killer point in my submission, is that what is actually sought here goes beyond access to physical infrastructure. They want, first of all, to go through the duct. Well, that's physical infrastructure, agreed. But they then want to get into the customer suite, put their own server there, and then connect their server directly to the customer. That's not about access to buildings anymore, physical infrastructure. That's going beyond even that broad point. So the Court of Appeal dealt with that point at paragraph 46. Of the judgment, which is on page 29 to 30 of the bundle, where Sir Patrick Elias confronted this point. He said it's a point which had caused him concern is whether GFS placing its server in the data center constitutes giving it access to the center, wrong question there in my submission, But I think that it does, given that access means making available facilities for the purpose of providing electronic communication services. Moreover, given that the concept of access is capable of including a positive requirement, I believe it's capable of extending to allowing GFS to access other servers. But what's lost there is that we've skipped here not access to Gib Telecom's service, but to customer servers. That's the missing link there. So if this echoes one of Sir Peter's points, if the purpose of access to the data center had been to interconnect with Gib Telecom's network, then because of the definition and inclusion of physical infrastructure in access, certainly for that purpose, to interconnect with Gib Telecom, they would be entitled to expect access into the building. They would also be entitled to place their server in it for the purpose of interconnection, I fully accept, because that's how networks interconnect. You put one server next to the other, plug them into each other, that's how networks talk to each other. You couldn't do it without. So for that purpose, I fully accept they'd be entitled to bring a server in under the access regime. But the missing part is the link to Gib Telecom's network. That's not what they're there to do. They want to go straight to the retail customer, straight to the end user. And I say they have no entitlement under the Access Directive to bring in a server for that purpose, and nothing in this definition allows them actually to sort of gain their own customers there without, of course, separate, independently negotiated commercial agreement of Gib Telecom. So it's true that, as I said, the best interests of end users is an important objective of the legislation, but that objective is served under this scheme by providing service providers and other network providers access to the network, not by providing a direct route in to the customers in a data center that they've specially built to house for the purpose. It's also true that within the scope of the directive, the obligation to provide access can include positive acts, as Sir Patrick highlights. And when he refers back to his earlier paragraph, he's referring back to the case of TDC. I shan't go to it now for reasons of time, but when my Lords consider it, I'll just point out that TDC, which is an Article 12 SMP case, is a case which established that an SMP operator can be required to adjust its network, including building it out by what's called a drop cable or 30-meter link from the network going down the street, 30-meter links to individual properties. It can be required to do that up to the network termination point in order for the requesting undertaking then to provide services over its network. So a positive act, build out the network so that another undertaking can provide a service over that network. So that's a great example, again, of a wholesale service being provided, of access to the network itself in order for that other company to provide a retail service to the end user over the network, having purchased that wholesale service. But again, that's not what is being sought here. And I can't go into all the authorities for reasons of time, but the point that I emphasize is no matter which of the authorities that you are taking to, they are all concerned with the provision of wholesale access to publicly available networks. None of them contemplate this situation, and cherry-picking quotes which are designed to explain the purpose of the access regime in that wholesale public context can't simply be read across to this context and said that shows what we're seeking to do is consistent with the purposes of the Access Directive. That's an illegitimate exercise in my submission. The last point...
You are running out of time, so
yes.
you don't have to wrap up in a few sentences.
May I do that very briefly? I've made the positive points that I wished to make. May I just remove very briefly several layers of prejudice which have been heaped on us. The first is that these customers are said to want to purchase GibFibre services. I don't know if that's true or not, let's assume that it is. But they, as end users, don't have a right under the Access Directive to access a particular provider's services. That's the final sentence of Article 1(2). The second is it said that what we're seeking to do is to put a substantial proportion of the market for electronic communication services in Gibraltar beyond the reach of the regulatory framework. That's a bootstrap submission. But my submission, of course, is my own friend seeking to extend the reach of the regulatory framework beyond its proper scope. The third is it said that we are seeking to distort competition in the provision of electronic communication services, and a suggestion that we've already been found guilty of an abuse of dominance by the GRA, which seems to be behind Sir Peter's submission that, well, we would love to do this if we could. We strongly resist that. There has been no finding of abuse of dominance. It is true that in the GRA's original letter, as well as the decision letter, it did make allegations of abuse of dominance, but as made clear, I'll give you the reference, in the decision letter, EB 181, when that letter was withdrawn, it made clear, or 193, this is paragraphs 45 to 46.1, that issue was now being treated as, quotes, academic, and that the GRA were not the competition authority. Had there been any finding, we would, of course, have appealed it. There has been no decision by a competition authority against us, nor has there been a private claim of abuse of domination against us, abuse of dominance. If there were, of course, we would defend it. In short terms, it's not for this court, but so you understand, Sir Peter alighted on it, there are other data centres in Gibraltar to which customers can go, including ones to which I'm instructed GibFibre have access. There's another one run by Sapphire, to which Gib Telecom does not have access, but Sapphire does. There is a market here, and whether or not there's an abuse of dominance would have to be separately investigated in the context of that market, with a proper full process with rights of defence on behalf of Gib Telecom. We haven't even gone there. So those allegations, my respectful submission, are pure prejudice and should be ignored by this court. You've been indulgent with my time. I hope it's been helpful, but I'm conscious of the need to sit down unless there's any further questions I can assist with before I do.
No, thank you very much indeed, Mr. Palmer.
My Lord, I wonder if your audience may be interested in my placing some recent information in front of the court about this is not argument on behalf of the court.
The question of competition law has been raised. I think the court, in the context of changes to the law, I might have mentioned this to them this morning, but I overlooked doing so. Unlike Ofcom, the GRA has not hitherto been a competition authority. Indeed, until very recently, Gibraltar has not had a body of national domestic competition law, and anybody wanting to complain would have to do so through the European Commission directly under the treaty provisions relating to competition. I just wanted to say to the court, in case they think it's of any interest to it, that in December 2020, Gibraltar legislated its own competition legislation, so there is now a body of national competition law in Gibraltar, and the GRA has been appointed a competent authority in respect of that. Your Lordships may know that Ofcom is one of 2 UK authorities under your competition laws, and that system is now being replicated in Gibraltar.
Thank you, Sir Peter. Well, Mr. Segan, I think you finally get to your feet.
Thank you, my Lord. My Lords, I wanted to make my submissions, if I may, under 3 broad headings. First of all, some introductory remarks about the nature of the appeal and the context in which it arises, and I hope in the course of those remarks to cover some of the commercial reality to which my Lord Reid referred this morning. Secondly, I hope to summarise the core of our positive case on the EU and domestic legislative provisions which we say empower the access sought by my client. And then thirdly, I shall address the 3 agreed issues in turn, dealing as I go with the submissions of the GRA and Gib Telecom. So I turn therefore to the first of those topics, which is the appeal and the context in which it arises. The question for the board, everyone agrees, is a pure point of law as to the scope of the GRA's powers. And the finding which my learned friends need to overturn is embodied in essence in paragraph 51 of the Court of Appeal's decision. It's at EB 33, Key Documents Bundle, tab 7, and in paragraph 51, in the 7th line, Sir Patrick Elias says, whether it would be appropriate to require such access, particularly where access to GibTel's network at Mount Pleasant can be obtained using the power conferred by Article 4, is not for this court to say. All that I have decided is that, in my judgment, and contrary to its understanding of its own powers, the GRA did in principle have an Article 5 power to grant access to GFS in order to enable it to place its server on the data centre and communicate with other servers, provided it thought it a proper exercise of its powers. And the debate is ultimately about whether a particular form of access, the form of access sought in this case, is within or outside the GRA's powers as a matter of law. In accordance with the very well-known approach to the interpretation of EU provisions, which we've summarised at paragraph 17 of our written case, the interpretation of the framework falls to be conducted by reference to the wording, the context, and the purpose of the relevant provisions. And I shall be submitting to your lordships, in essence, that all three of those factors, the wording, the context, and the purpose, confirm the correctness of the decision of the Court of Appeal. Given the importance of context and purpose in the interpretation exercise, I should emphasise at the outset that this appeal arises against quite a stark background in terms of the core objective which is pursued by the Common Regulatory Framework, which is the promotion of competition in the delivery of electronic communication services. That is what the CRF exists for. It's the core objective, and I'll be showing you it's at the heart of the Article 8 objectives in the Framework Directive. Gibraltar Telecom is, as you will have seen, the historical incumbent telecommunications provider in Gibraltar. It's the equivalent of BT in the UK, albeit unlike BT, it remains 100% government-owned. This case arises because Gib Telecom has used its accumulated resources to develop two large data centres in Gibraltar. And as has been explained by my learned friends this morning and just now, within those data centres are the servers of many of the largest consumers of electronic communication services in Gibraltar. The very reason that the customers put their servers in a data centre is that they need very substantial bandwidth to operate, as well as a secure environment for their servers. Even at the time of the request in 2015, Mount Pleasant hosted 5 important customers in the gaming sector. That's the judgment of Mr. Justice Butler at paragraph 22. The numbers have, as I understand it, grown very substantially since then. What is more, it is common ground that what Gib Telecom then does within the data centres is to deliver electronic communication services within the meaning of the Common Regulatory Framework. And we've given some of the references on that in paragraph 5 of our responsive written case. That's tab 5 of the Key Documents Bundle at EB 584. Those servers are then connected to the outside world by means of electronic communication services provided by Gib Telecom as well as by Sapphire, and that's also agreed in paragraph 3 of the Statement of Facts and Issues. So the services which are actually being delivered to the customers within the data centre are indubitably services within the scope of the Common Regulatory Framework. It's also common ground that GibTel has entered into an arrangement allowing Sapphire, another communications provider in Gibraltar, the precise form of access to the data centre that my client is seeking. That's paragraph 4 of the Statement of Facts and Issues. What is more, the wires that actually connect Sapphire's network to the end customers in the data centre are laid and owned by Gib Telecom. And one can see that in the judgment of Mr. Justice Butler at paragraph 20. That's in the Key Documents Bundle, tab 9, Electronic Bundle, page 73. GibTel lays fibre from Sapphire's equipment at Mount Pleasant to a patch panel in the same room where other customers' servers are racked. The other end of the fibre is patched to the other customer for whatever purpose Sapphire wishes. GibTel handles everything. The whole purpose of data centres laying fibre on customers' behalf is to minimise the amount of fibre required as much as possible in order to keep things manageable. So it's all arranged by GibTel. My client, as you will have seen, has built its own fibre optic network in Gibraltar. And without the ability to connect to the customer servers within the data centre, GibFibre is left unable to compete in a substantial part, indeed by definition the most data-intensive part, of the market for internet services in Gibraltar. To use Sir Peter's words from this morning, those customers are forever inaccessible to GibFibre unless they can be persuaded to move their servers, go through the whole rigmarole of moving their servers to another data centre. Indeed, the more customers that Gib Telecom can tempt into their data centres, the larger the parts of the market which are entirely foreclosed from competition and left for Gib Telecom to decide how it would like to serve. And that is conduct which the GRA, as I shall come to in a moment, has already found long ago is causing substantial distortions in competition in the market for electronic communication services. All my client seeks is the same arrangement already enjoyed by Sapphire, to run its network cables into the data centre via the ducts. I pause there to emphasise the ducts were found to be an associated facility. So the suggestion that the request for access does not concern any associated facility is wrong. We want to run our network cables into the data centre via the ducts, place a server on the racks, and then cross-connect in exactly the same way as Sapphire does. I can gather together all the references overnight to our seeking the same or a similar deal, since there seemed to be some suggestion that that might not be right, but one can see it most obviously from paragraph 1 of the Court of Appeal's decision, which records that what we want is a similar arrangement. But Gib Telecom has now refused for nearly 6 years to grant any such access. As you will have seen, it was initially claimed that there was a problem with the capacity of the ducts. That was investigated by the GRA and found to be untrue. And ultimately, Gib Telecom has been driven to acknowledge that the true reason is purely commercial. It simply does not wish to allow my client to compete with it and Sapphire in the market for electronic communication services to these customers. Indeed, on Gib Telecom's argument and the GRA's argument, there would be no regulatory objection if Gib Telecom were to eject Sapphire tomorrow, subject to whatever contractual arrangements are in place, and reserve the relevant market entirely for itself. As I say, that is conduct which, some time ago, the GRA concluded was causing substantial distortions of competition. And one can see this from the decision letter of the 14th of June 2016, which is at Electronic Bundle, page 1378. This is the 14th of June 2016 decision letter by which access was ordered in the first place before the GRA changed its view on the law. And there is an extensive analysis from page 1382 onwards in the context of the objective of promoting competition of all the respects in which the GRA had formed the view this conduct was distortive of competition and was indeed an abuse of dominance. Dominance is dealt with in 1383 to 1384, but the distortions of competition, in particular what it found were abuses, are dealt with from page 1384 onwards.
I mean, doesn't that suggest that there may be an alternative avenue for you to address what you're complaining of now, namely a complaint of abuse of dominant position, which would obviously go through all the hoops such a complaint would have to go through, rather than necessarily trying to address that problem via the interpretation of the Access Directive?
Well, obviously one can always bring a claim for abuse of dominance. That must be right. But one of the important points that I'm going to be developing when we come to the points of construction is that your lordships in my submission need to favour the interpretation which furthers the underlying objectives of the CRF, the most important of which is the promotion of competition in the market for electronic communication services. And so, leaving aside the question, my learned friend Mr. Palmer cavils at the particular findings in relation to abuse of dominance, but there can be no question from this analysis in the decision letter, which goes all the way through to page 1388. And at 1388, they actually summarise the particular concerns from a competition perspective. That this conduct is seriously distorting competition in the market. Indeed, in a sense, one doesn't need 7 pages of analysis to get to that point, because, as I've said, the necessary consequence of the argument, if correct, is that the more customers are in the data centre, the greater the distortion, because the larger the proportion of the market that GIB Telecom gets on its argument to reserve to itself. So it is relevant, we say highly relevant, to the question of construction, because the effect of the submissions on appeal is that the data centre becomes a kind of regulatory no-go area. The submission is that by the magic of the interposition of a relatively limited amount of internal data centre cabling between the ducts and the customer servers, one creates an impermeable barrier to intervention by the regulator at all. And we say the Court of Appeal was quite right to reject that case. That brings me to the second main topic, which is our positive case on interpretation. Let me just summarise it very briefly. The starting point we submit is with the Framework Directive, which governs the whole structure and operation of the Common Regulatory Framework. That is in Authorities tab 2 at page 620. The operative provisions start at page 630. But I think I can take you straight to Article 8 at page 641. Member States shall ensure that in carrying out the regulatory tasks specified in this directive and the specific directives, the national regulatory authorities take all reasonable measures which are aimed at achieving the objectives set out in paragraphs 2, 3 and 4. Such measures shall be proportionate to those objectives. Subparagraph 2 is the NRA shall promote competition in the provision of electronic communications networks, electronic communications services, and associated facilities and services by inter alia. And then we have ensuring that users derive maximum benefit in terms of choice, price and quality, ensuring there is no distortion or restriction of competition in the electronic communications sector, including the transmission of content. We then have, in paragraph 5, the national regulatory authorities shall, in pursuit of the policy objectives referred to in paragraphs 2, 3 and 4, apply objective, transparent, non-discriminatory and proportionate regulatory principles by inter alia, and then there's a reference in B to ensuring that in similar circumstances there's no discrimination in the treatment of undertakings providing electronic communications networks and services, safeguarding competition, and so on and so forth. So a core objective of the scheme is the promotion of competition. And as we set out in the first paragraph of our written case, that has been confirmed by the Court of Justice as imposing an obligation on NRAs to take all reasonable measures aimed at promoting competition in the provision of electronic communication services, ensuring that there's no distortion or restriction of competition. That's Commission and Poland. I'll just very briefly take you back to some other relevant provisions in the Framework Directive, which come up later on, so we don't have to go back. Article 4, page 636, is the right of appeal. This is going to be relevant to the safeguards that exist in respect of the exercise of the Article 5 power. Member States are required to ensure that effective mechanisms exist at the national level, etc. In short, there is a right of appeal against a decision by an NRA, and that appeal is required to take the merits duly into account. So it's not a judicial review. This is a point that Lord Sumption makes at paragraph 13 in Telefonica. When we get there, it's more than that, it's a merits appeal. Article 6, at page 637, is the consultation and transparency mechanism. So there's a requirement where measures are going to be taken in accordance with the directive to hold a consultation with the affected party if there's a significant impact on the relevant market, and there are equivalent provisions as regards pan-European effects in Article 7. So that's the framework. One then needs to move to the Access Directive at Authorities, tab 1. I shall obviously be coming back to this in greater detail, but I just want to let you have our court case before I sit down. Recital 3, page 597. The term access has a wide range of meanings, and it is therefore necessary to define precisely how that term is used in this directive. So there is a specific reference to the need to define access precisely. One then finds that definition at page 604. Article 2, subparagraph A. Access means the making available of facilities and/or services, entirely general, to another undertaking under defined conditions on either an exclusive or non-exclusive basis for the purpose of providing electronic communication services. So the provision identifies, as my Lord Sales observed earlier today, the relevant purpose, including when they are used for the delivery of information society services or broadcast content services. It covers inter alia, and access to network elements and associated facilities is simply one of the examples of what access may entail. It includes access further on to physical infrastructure, including buildings, ducts and masts, and one can read on. The core of the definition is the making available of facilities and/or services to another undertaking under defined conditions for the purpose of providing electronic communication services. Now, as I understand it, nobody Subject to the scope point, nobody disputes that what we are asking for falls within that definition. One then needs to look at Article 4, which is the specific provision concerned with interconnection, but it does cross-refer to Article 5, so page 605, last sentence. Operators shall offer access and interconnection to other undertakings on terms and conditions consistent with obligations imposed by the National Regulatory Authority pursuant to Articles 5 to 8. Then Article 5, which of course is the critical provision in our case, page 606. Headed powers and responsibilities, so clearly concerned with powers. Subparagraph 1, NRAs shall, acting in pursuit of the objectives set out in Article 8 of the Framework Directive, so I pause there to note that the pursuit of the pro-competition objectives in Article 8 of the Framework Directive is actually baked into Article 5 itself. Encourage and, where appropriate, ensure, in accordance with the provisions of this directive, adequate access and interconnection and the interoperability of services. And then, one gets the references to promoting sustainable competition and the such like.
To pick up my Lord Legate's question, what do you say access is to there? Adequate access to what?
Well, that's answered in the definition of access itself. Access means the making available of facilities and or services to another undertaking under defined conditions. So it's actually facilities or services.
Well, that might be fine if the word access is used somewhere else, and in a free-floating way, as it were. What you're just afforded is access, and then you look to the definition to see to what. But it isn't where it appears in the other provisions. It's access to something. And so it's limited there to the something.
Your Lordship is putting to me the scope point there, and clearly I'm going to be coming to that. There is an important point that the ducts are an associated facility. So the case that has to be made is that the request must relate entirely. None of the infrastructure touched by the request can be anything other than a network element or an associated facility. And that, we say, simply cannot be right when one looks at the definition of access. It cannot be right when one looks at it in the broader context of the wording of other provisions of the directive, to which I shall come. It can't be right in the context of the overall objective of the directive, which is the promotion of competition, because its effect, one only needs to look at this case to see what its effect would be were it correct.
But do you accept that your clients are not seeking access to Gibraltar Telecom's network or associated facilities?
No, I don't, because of the ducts. That's an important qualification.
The ducts are only covered if they provide or if they enable and or support the provision of services via the network.
Yes, and in paragraph 38 of the Court of Appeal's decision, the Court of Appeal record that it was actually conceded by the GRA. I think it's paragraph 38.
It's not being conceded by Mr. Palmer. And I don't think it's being conceded now by the GRA either.
Well, there's been no determination to the contrary, my Lord. My learned friends are, as I understand it, relying on the findings of the Court of Appeal in this regard.
But we know the ducts in question are before you reach the termination point where people plug into the network.
Yes, that's right. The termination point, the precise location of the network termination point, this is a point we make in our responsive written case, has not been the subject of any determination either by the Court of Appeal or by the regulator. So,
well, we're told that it means that the physical point at which a subscriber is provided with access to a public communications network. So that clearly isn't in the room where the servers are concerned, from what we've been told.
One could say, as GibTel say, as I understand it, it's the carrier room. One could say equally, given the definition of network termination point as being the point at which the customer server gains access to the public electronic communications network, it has to be the point at which their server is connected to these internal wires that join it to the carrier room, because that's the point at which they are accessing the signal.
Well, if we're going to have arguments of this kind, then the case has to go back for the facts to be established.
But, my lord, to answer your question directly, I do accept that there are findings of the court below that the second and third elements of the access, which we are seeking, namely the placement of our server on the rack and the connection to the customer servers, are not requests to a network or an associated facility.
So it's purely the ducts, is it?
Well, if it be correct, if the argument were correct, that access can only relate in terms of physical infrastructure to the network or an associated facility, then that would be right. However, our submission, and the submission I'll be developing in the context of Ground 2 on scope, I expect tomorrow now, is that submission simply cannot be right, that access is only to physical infrastructure comprising the network or an associated facility, because that is inconsistent with the definition of access itself. And as I say, it's inconsistent with the underlying purpose pursued by the regime. And it's also inconsistent with some other provisions of the directive which I'm going to be showing you.
But the Court of Appeal found, did they not, that in relation to Article 12, that the access you were seeking was in two respects not limited to network and or associated facilities, and there's no appeal from that conclusion.
Yes, that's right, and that's what I was intending, my Lord, to accept in my answer to my Lord Reid a moment ago. So
so you say it has a narrower scope in Article 12 than in elsewhere in the directive, or in the provisions?
No, my Lord, and the reason for that is that Article 12 itself is this is a point made by the Court of Appeal, is explicitly limited to access to network elements and associated facilities.
So is Article 1, 2, which sets the framework for the whole directive.
My Lord, if it were correct that defined the entire ambit of the directive, then of course that would follow. The directive in my submission has to be read as a whole, has to be read consistently with the underlying purpose. When one reads it as a whole, it's perfectly clear in my submission that when one puts the definition of access together with the obligation in Article 5, it is simply not right as a matter of interpretation to say that access can only ever relate to physical infrastructure, which in itself comprises the network or an associated facility. And obviously I'll be developing that submission by reference to the cases that we cite and indeed the wider provisions of the directive in due course.
I wonder, is that a convenient?
I think it's probably as good as any, my Lord, yes.
Very well then. Well, thank you very much, Mr. Segan. We'll adjourn now for the day and resume at 10:30 tomorrow.
Thank you, my Lord.